Good evening. That's okay, they're civically engaged. That's fantastic. I'm Peter Gunn. I'm a faculty member here at Williston Northampton, and on behalf of the school, we're delighted that all of you could be here, and for those of you who get a chance to view this at home, we're delighted that you're devoting some of your time and attention to the exceptional work that's being done by students in the city of Easthampton, both at Easthampton High School and here at the Williston Northampton School. It's a terrific honor. I can think of many things that I would like to say, but I'll limit it to three, and then I'm going to introduce our headmaster, who will give you a formal welcome, and then we'll go over the logistics of where people go and what comes next. The Center for Civic Education and the We the People program is dedicated to encouraging young people to be engaged. So our first goal tonight is to further that development, take that to the next step. Our second goal is that this will be an effective complement to what I know is already a rigorous advanced placement curriculum that you are all studying. The third goal, and I think that this is something that I hope Ms. Brown will join me in and concur, is that we're also hoping that this will be the first step towards ensuring that the state championship for the Commonwealth of Massachusetts remains in the city of Easthampton for another year. For those of you who don't know, Easthampton High School is defending state champions. I had the honor of watching them last year. They did an extraordinary job, as I'm sure they are again this year, and we're looking forward to joining them in the competition. But at this point, I'd like to introduce our headmaster at Williston Northampton School, Robert Hill. Bob. Thanks, Peter.
Peter, you said a formal welcome. This will be an informal welcome, but a heartfelt one. And on behalf of the whole school, I do want to welcome everyone here, especially our guests, and especially those of you from Easthampton High. And not everybody knows, but Peter is in his 13th year of doing this, Peter, We the People,
yes,
14th
yeah.
year of competition of We the People. And I believe it was his collaboration with Easthampton High which got you guys going on, or y'all going on, as they say down south. And then for you to bring the championship to Easthampton is fantastic. And we kind of feel like we're sharing part of that tonight with you. So I agree with Mr. Gunn when he says, let's keep it in Easthampton. Absolutely, let's do that. And who would have thought when Governor Morris was penning these words, these We the People words, which have brought all you guys here tonight, that, you know, by golly, there's an app for that. So I can pull up my app right here of We the People of the United States in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and to our posterity, to ordain and establish the Constitution of the United States of America. And you guys, you young people here who are making this a study, and a lifetime study really, deserve our great praise as the older generation, because it's up to you who are going to keep those words living and embody those words the rest of your lives. So I want to give you guys a shout out and a thank you, and then turn it back over to Peter. So thank you.
Thank you very much, Bob. Kelly Brown from Easthampton High is going to join me, and we're going to go through the logistics. The one thing that I will tell you right away is we're not all staying in this room. So those of you who are standing in the back, when we divide up into three, we hope that everyone will be able to find a chair or at least a comfortable wall to lean against in the rooms. The three spaces that we're using this evening, this is the Dodge room. Directly above us is room 211, and there's a stairwell right outside the door. And you go up that stairwell, and it'll bring you right out next to the room that two of the units will be in. And then all the way down the hallway on the second floor in 204 is the third space. We'll go over which units are there in a moment.
So welcome. My name is Kelly Brown, for many of you who don't know who I am, and I'm the AP US History teacher at Easthampton High School. And I just want to thank everybody for being here. This is a fantastic crowd of people. I know that my students are very excited and they're very nervous. And as I'm sure the students from Williston are as well. But the one thing I want to say just before we share some logistical directions and get out of this room is that this really is an opportunity for all of you, Williston students and Easthampton students, to show what you know. And this isn't about a quiz or anything that you're supposed to know a specific right answer to, this is really your opportunity to spend time tonight kind of demonstrating what you know about the Constitution, about what you understand about history. And I think we had a lot of luck last year in that we really kept that attitude. It was like, okay, I have 4 minutes to show what I know and what I've learned. And I know my students have been working terribly hard at this. I know that you guys have been working hard at this. And this is your chance to just show some people in the community what you know. And that's a really special experience. And it's a special experience for them, and it's a special experience for you. So before we proceed tonight, I just want to say, toss those nerves aside and take the time to just share with the people that are here tonight what you know, because you know a lot, and it's very impressive. I watch my students every day, and I'm very impressed by the work that they do. So I wish you all the best of luck tonight, and I just am really happy to be here. It's a lot of fun. It's wonderful also for me to say that 6 of the 9 students that competed in Washington, D.C. last year are here with us tonight to act as judges in the rooms with you. So they are somewhat experts at how this process works, because they not only had to do it at the state championship, but they also had to do it at the national championship in Washington, D.C. They're sort of crowded in the door right now, but if you guys could sort of raise your hands. They're in the back. So for those of you who are judging tonight, those young people in the back are the keepers of the questions and the follow-up questions, and they're also the keepers of how this process works. And so when you see a young person with a yellow folder in your room, if Peter or I am not there, they will be happy to help you and direct you into how this process is going to work. And if you have any questions for them, you can feel free to ask, and they will absolutely share whatever they know. So they will help you to kind of work through the process, and I think after the first round or so, you'll have it down. So.
Great, yes. Please, I know that you can put your trust in those folks that do a great job. I'm just going to run through this once again, and if you would, can I convince those 6 to eat into the room so that the judges can see them? Because I'm going to announce your name with each unit. Units 1 and 3 are going to be staying here. Okay, perfect. This is even better. Come on. This is good. Okay? I have some follow-ups, Tom. Like, you want to go over now? No? No? Okay. Units 1 and 3 will be staying here. Unit 1 judges are Rich Cairn, Alice Evans, Sarah Sawyer, and Bailey Murphy is your guide. So Unit 3 will also be here, and for Unit 3, Joy Winnie, Amy Davis, Tristan Koopman, and Diane Williams. Okay? And here's Tristan. Upstairs in room 204, Unit 2, and Tom Palashak. Battery's going to quit on this, so we're going to go fast. Along with Hamdi Dalal, Joel Wolf, Brian Rissler, and Lori Rissler. Okay, you'll be going to 204, and you'll be with Unit 5, and Zach's on the list here.
Oh, Felicia came
okay.
out of college to come
this
and join
is Zach
us.
Lewis, rest of the Felicia Therian. So going with Felicia will be Kathy Kay, Nancy Sykes, and Rick Teller. And then in room 211 for Unit 4 with Michael Palashak is Dave Korkowski, Vito Perrone, and Lori Ingraham. And then Unit 6 with Willow Roth here to my right, Michael Engel, Deb Luznia, and Andrew Seifert. So I hope that I've got all of that. Did I get everything?
Yeah, I think that sounds about right.
Okay.
We'll kind of have to stumble our way up to those rooms. If someone from Williston who's heading up that way could be a leader, that would be lovely. Because while these guys have the folders, they don't necessarily have the directions.
And just again to review the format that we go through, the students will have 4 minutes approximately to make a formal presentation from a script. They will then set aside their notes and be asked a set of follow-up questions that the judges have. And really the purpose there is to engage in a conversation and do exactly what Ms. Brown spoke of before. Show what you know, explore what you've learned, talk about how it's relevant both historically and today. It's really designed to be a conversation, and at the end of about 4 minutes of that conversation, we ask that the judges give the students some feedback about how well they presented the material, things that they could do that might help clarify their presentation as they move on to preparing for the state competition at Harvard at the end of January. For those of you who don't know, all of these students are preparing to do the same thing again at the Kennedy School of Politics at Harvard University on Saturday, January 26th, 2013, and we hope that many, if not all of you, or perhaps even more, can join us and them on that occasion as well. It's really stunning to be in those rooms and to listen to the conversation that these folks will develop. So we're going to see 4 presentations in each room, correct? Okay, and there's a schedule that's set. Ms. Brown will stay here in the Dodge room. I will be upstairs in 211, which means in 204 for units 2 and 5, I will be right down the hall. If anything comes up or you have any questions, and I'll try to pop down and check in with you. We'll all then reconvene briefly at the end just to congratulate folks on the evening and send you on about the rest of the evening.
Before everyone leaves, I just want to say a special thank you to the judges who are volunteering their time to be here tonight. We have a lot of community members, people from the 2 schools, people who have been volunteers and have helped out with certainly with my Lose People program and also with Peter's. And so if you have a chance tonight, if you're here as a parent or if you're here as a student, make sure you thank those judges for being here because they volunteered their time to come here and be a part of our event tonight. So I just want to take the moment to thank them for being here and recognize them for that. So without further ado, I'm going to let the judges sort of run the process here, and they're going to go ahead and take over. A Williston team is going to start for Unit 1. Then an Easthampton High School team will present for Unit 1, and then I believe the order it goes in, an Easthampton team will do Unit 3, and then the Williston Unit 3 will end the evening. So, okay. Thank you.
Good evening. I am Bailey Murphy. I am a senior at Easthampton High School, and I did Meet the People last year, so I know what the program is about.
I'm Allison Evans. I'm currently doing my practicum with Kelly Brown, so that's how I got here.
Hi, I'm Rich Cairn. I work at the Collaborative for Educational Services, which is a nonprofit organization based in Northampton, and I run a graduate program for history teachers at all grades.
Hi, I'm Sarah Sawyer, and I direct the Writing Center here and teach English.
Hello, I'm Henry Lombino. I'm a junior.
I'm Persis Tickner-Swanson. I'm also a junior.
I'm Rachel Lloyd. I'm also a junior.
I'm Jackie Husis. I'm also a junior.
Okay, Williston, tonight we are going to ask you question 2, which states, recently a historian has written that the colonists looked upon themselves as Englishmen, entitled to the rights of Englishmen, of which they regarded Magna Carta to be the chief embodiment. How would you explain what is meant by the rights of Englishmen? What provisions of the Magna Carta established those rights? What principles important to the latter development of constitutional government are set forth in the Magna Carta?
Thank you. In 1215, feudal barons of England met with King John at Runnymede. King John had created an oppressive government that ignored the barons' rights. The barons forced King John to sign the Magna Carta, guaranteeing that John or any future king of England would not be able to ignore certain rights of the nobles. Thus came the first written description of the rights of Englishmen. The rights of Englishmen are fundamental, cannot be taken away, and give every male citizen of England a certain amount of power. These rights include the right to trial by jury, the right to keep one's property, and the right to be taxed only with consent. Unlike the United States Constitution, the British government did not and still does not have official written constitution that limits the power of government. Instead, the rights of Englishmen were and still are based off common law and tradition, set in historical documents such as the English Bill of Rights, the Petition of Right, and the Magna Carta, and grew over time to become accepted as unalienable. The Magna Carta secured only for nobles certain rights that the king could not take away. Today, however, these ideas of an agreement between rulers and subjects and unquestionable rights have spread to include all English citizens. These rights also grew not only with new additions of the rights that the English once secured, but the degree of which these rights were accepted as unalienable. Eventually, these rights were considered completely binding and fundamental and came to be a large part of the British citizens' pride in being English. As Cecil John Rhodes said, quote, "Remember you are an Englishman and have consequently won the first prize in the lottery of life."
The Magna Carta sets out laws and rules that are meant to protect previously established rights set by precedent. As a contract, it is signed and agreed upon by both the ruler and the ruled, and establishes the idea of an agreement that should not be violated because both sides have mutual investment in it. Article 39 protects the right to trial by jury, stating, quote, "No freeman shall be taken or imprisoned or exiled in any way or in any way destroyed, nor will we go upon him nor send upon him, except by the lawful judgment of his peers or by the law of the land." This is a right that carries through time and is protected by future constitutions in America. Article 63 states that those rights are guaranteed not only to signers, but to others in future generations. This idea contributes to the belief that unalienable rights are permanent, cannot be taken away, and given at birth. The protection of property is also present, with Article 28 guaranteeing that, quote, "No constable or other bailiff of ours shall take corn or other provisions from anyone without immediately tendering money therefor, unless he can have postponement thereof by permission of the seller." This defines the right of property as belonging to the owner, and that those of authority cannot take away that right of property without the consent. The Magna Carta provides for protection of certain rights of Englishmen that establishes a precedent for future contracts of the same sort.
The rights and principles the Magna Carta establishes, such as common law and constitutionalism, are still used today. Common law is the accumulated legal opinions of judges explaining their decisions in specific court cases. Their decisions are applied to later cases so that they will be judged consistently. In the Hadley v. Baxendale case in 1854, a common law is established. Hadley tries to charge Baxendale with the cost of keeping his mill closed for extra days because Baxendale returned Hadley's crank later than their contract stated. However, the judges ruled that since the mill being shut down for extra days was an unforeseeable consequence, Baxendale should not be held accountable. The precedent is that a breach in contract can't be recovered if the damages weren't foreseeable and is still used throughout court cases today. The Magna Carta is the first of 4 documents to be adapted as part of the British Constitution. The Petition of Right, English Bill of Rights, and the writ of habeas corpus follow it. However, the Magna Carta is the first step in creating a constitutional government, a government in which power is distributed and limited by a system of laws that must be obeyed by the rulers, and it lays out the groundwork for the United States Constitution.
The Magna Carta establishes ideas that also contribute to rule of law and social contracts. Rule of law requires the king to govern according to established rules. The purpose of the Magna Carta was to make sure the king had limited power over the nobles. A current example of a constitutional government is how the United Nations Treaty will ban discrimination against people with disabilities. States are worried because they have to change state laws and regulations to follow this treaty. The way people with disabilities are being treated in society, becoming a law, is an example of an addition to social contract. The purpose of the Magna Carta was to ensure the rights of life, liberty, and property. Creating a treaty for those with disabilities creates the controversial issues of liberty. The government's job is to protect people's natural rights, and that is what the UN is currently doing. We have decided to agree with Henley's thesis. Thank you. We are now ready to answer your questions.
Okay. How did the Magna Carta help establish limited government within England?
The Magna Carta set up the idea of meetings between nobles and the king, and the nobles at that time at Runnymede were unsatisfied with what the king was doing, and they decided to take their own action. And so that became the beginning of the nobles setting limits on what the king cannot do. They did not want him to tax them. They did not want him to take away their certain traditional rights that they had considered their own. And so that eventually evolved into Parliament, which is now today the limiting power on the king in England.
Also, I'd like to add to my colleague that the Magna Carta was the first written example of the rights of Englishmen, the first written description of them. Before that, the rights of the barons were more unspoken, an unspoken agreement between the barons and the king. King John, however, violated those and did as he pleased, which angered the barons, and thus they forced him to sign the Magna Carta, thus guaranteeing on paper that they would always have those rights.
I had a question about the idea of things being on paper. sure you're not surprised.
Of course.
But I was wondering, when you were talking about these documents that get written down and last through the ages, and how they might attach to natural rights, like you were talking about the UN, or about the rights of barons or of Englishmen. So I wanted to know how are the rights of Englishmen similar or different from natural rights, since you talked about those in wildly different time periods.
Mm-hmm. Well, the rights of the barons were more the rights that were specifically listed in the Magna Carta, which were vastly different from what we consider natural rights, like the rights that were listed in the Bill of Rights, which were considered natural rights, like the right to free speech. The right to free speech was not listed in the Magna Carta and kind of evolved from the ideas listed in the Magna Carta, and the idea that it belonged to everybody, whereas the freedoms in the Magna Carta were only for the barons.
So natural rights would shift.
Yeah, natural rights were more of birthrights that should be given to you, but what the nobles wanted was like more than that. That's why they had to make an agreement with the king.
I would also add that natural rights was an idea that came along with Locke, who came along much later than the Magna Carta, and that the Magna Carta was specific to those nobles at that time, but natural rights was a Locke theory that was applied to many more people.
I'd also add that the Magna Carta was almost the first step in creating the natural rights and being able to set down rights in paper, and later Locke, the rights of life, liberty, and property, and then later in the Constitution adding people's rights. It was like the first step.
I would also add that natural rights are natural. They are not written down, usually, unless they need to be guaranteed by government in fear that the government will squander those rights, which was another idea of Locke.
I had a question. To what extent are the rights of Englishmen dependent upon the power of the sword? Both the limits on those rights and the maintenance of those rights, power of the sword, power of violence. I mean, to what extent is this constitutional issue, and to what extent is it just who's got the power?
In English history, it has often, as opposed to American history, except for one instance, has dissolved into violence over like who has the power. Especially, it's a struggle between the kings and the nobles, and then eventually like the people who the king has never ever really looked at. He's never been. His purpose isn't to look out for the rights of the people, and so it ended up being conflicts like the Civil War, the English Civil War, and that they, like, the power of the sword for the English is more of regulating between the two people, and the king creates more of a balance, whereas in America it's done through talk and conversation.
I would also add that the reason that King John was forced to sign the Magna Carta is because he needed the barons' help to...
We're actually out of time for our questioning round, but it sounded like you were going to go somewhere very good with that. So, right now, if the judges will join me, we will give you guys some good feedback, followed with maybe some improvements that you can make.
I get to ask a question. I think that all of you, when you were doing your questions, I liked how all of you made sure that you spoke and you added onto each other with positive points that reinforced what your partner was saying, which was really well done. And I also, the projection of your voices was really easy and clear to hear all of you speak, which was great.
I thought so too. I was really impressed with how quickly you were able to add on, and I think, I was sort of wanting the Locke answer, and I thought that really added to that answer quite a bit. I think that when you're sort of adding on to each other, it does give a general impression of learnedness, which is impressive.
This is hard to say when it's a formal presentation like this, but relax a little bit. Make it sound like you're having fun, You were accurate. Your reasoning was strong. You were very serious. You know, how can you be? You know, you're not here to tell jokes, but work on presentation where you're giving a little bit of who you are, not just the words.
I thought you guys did very well. I liked how you guys looked up when you were speaking. One thing I might mention is that maybe when you're speaking or just sitting there, smile a little bit. It looks nice. It doesn't look like you're completely bored or like you're extremely nervous.
Wow.
Yes.
Right.
I know that. But other than that, I thought you guys did very well.
One little tiny thing is, Henry, I think you want to say inalienable rather than unalienable.
Oh, yeah. I would change that. Thank you.
Just to
I really liked the point that you were making about the current debate, which is in the news this week, about the rights of people with disabilities. It's something I'm very interested in, and it was an interesting sort of relating a particular point to something that's very current. It was a fairly complicated point, and there was a lot there. So I want to polish a little bit just how you hit the point. But it was really good to bring that in, and it you know, you didn't pull that out of the textbook. It was something you guys thought about and put in there.
Can we give this group a round of applause?
Okay. Good evening, Easthampton. I am Bailey Murphy. I'm a senior at Easthampton, and I did meet people last year, so I know what's going on. I know what you guys are going through right now.
I'm Allison Evans, and I'm doing my practicum with Kelly Brown right now.
Hi, I'm Rich Cairn, and I work at the Collaborative for Educational Services in Northampton, and I run it's essentially a graduate program for history teachers to work with each other.
And I'm Sarah Sawyer, and I direct the Writing Center here and teach English.
My name is Jessica Ingraham. I'm in 10th grade at Easthampton High School.
My name's Anissa Payan, and I'm a sophomore at Easthampton High School.
I'm Jacob Lopred, and I'm a sophomore at Easthampton High.
I'm Kevin Van Odenhove, and I'm in 10th grade at Easthampton High School.
My name is Gabe Ferguson, and I'm in 10th grade.
I'm Kate Abar, and I'm a sophomore at Easthampton High School, and this is our teacher, Kelly Brown.
Okay, we would like to hear your response to question number 3. On the 50th anniversary of the Declaration of Independence, Thomas Jefferson, its author, wrote that the object of the Declaration was, quote, not to find out new principles or new arguments never before thought of, but to place before mankind the common sense of the subject, in terms so plain and firm as to command their assent, and to justify ourselves in the independent stand we are compelled to take, end quote. What were the main ideas or principles set forth in the Declaration? Jefferson freely acknowledged that the Declaration borrowed from the works of Aristotle, Cicero, Locke, Sidney, etc. What are some of those ideas borrowed and used in the Declaration? And do these principles and arguments have relevance in the world today? Explain your answer.
The English colonists declared their independence with a document that borrowed ideas from Aristotle, classical republicanism, Enlightenment philosophy, and British history. They used well-known philosophy to justify their actions. The basic principles mentioned in what we know as the Declaration of Independence became a foundation for the American Constitution. The Declaration continues to inform, shape, and challenge government, society, and people across the nation.
The Declaration of Independence justified American independence from Europe by setting forth the principles of natural rights, human equality, mixed government, the right to revolution, and social contract. By combining these principles, Americans sought recognition and approval for their declaration. John Locke, a philosophical thinker, introduced the idea of natural rights, which were God-given rights that people were born into, including life, liberty, and property. Americans came together to create the Constitution and protect their rights they were denied from Britain. By starting the preamble stating, "We the people," a social contract is shown.
The idea that the colonists used to justify revolting against the English government. Human equality was used in the Declaration and borrowed from Locke, Hume, and Rousseau. They believed that all humans were politically equal and they could not be deemed at birth to rule over others.
The founders used the idea of mixed government from Aristotle. Aristotle's idea of mixing monarchy, aristocracy, and polity reduced the bad form of these governments to form. The British monarch, King George III, deprived the colonists of their rights, and the colonists saw the British government as an absolute tyranny. Algernon Sidney stated that free men always have the right to resist tyrannical government.
This led to the idea of right to revolution. Sidney strongly believed in the right to overthrow government if it becomes too powerful or destructive. The colonists had the right, because of social contract, to come together, abolish the unfair government of Great Britain, and create free and independent states. Citizens of the United States still have this right today. However, it is more implied in the Constitution than stated.
The Enlightenment and the influence of classical republicanism helped bring forth government by consent. The colonists needed to protect their natural rights, and they would only agree to a government if it protected those rights, which Britain failed to do. Although the founders were weary of British government, they agreed with their constitutional principles and borrowed from Britain's Petition of Rights and Bill of Rights. The founders protected individual rights by creating strict limitations on government. Rousseau, who had a strong distrust in government and society, believed all governments needed limitations. Understanding Britain's mistakes in their government and using ideas of Roman, Greek, and philosophical thinkers helped the founders form the Declaration of Independence.
The Declaration included all of the King's failures in protecting the colonists' rights, like the right to a fair trial. Today we use the concept of innocent until proven guilty as a way to keep trials fair. The United States government, along with the concept, uses the philosophical reference habeas corpus, meaning that no person can throw another person in jail without a reason for doing so. A person must be charged first. The King had not treated the colonists as British citizens, so in the Declaration, they wanted to include all men are created equal. In the Abington School District case versus Jemp, the phrase all men are created equal was the deciding factor that led to the jury finding that colored people having their rights denied to education was strictly unconstitutional. The Declaration of Independence contributed important principles to the Constitution that are still in force today. Thank you. We are ready for your questions.
Okay. How do we use innocent until proven guilty today?
We use this concept by saying that if there isn't sufficient enough evidence to prove someone that they committed a crime, that they are innocent and cannot be charged with that crime.
If I may add to that, a person, even like a king in a country, cannot just put another person in jail just because they feel threatened by them. They have to bring them to court and have a trial of their peers. Here a trial of one's peers have to be in the jury, and they have to provide sufficient evidence along with witnesses that prove that this person has committed that crime. If not, the person has to be released.
I'll ask one. So, other than Locke, who most influenced the principles and ideas of the Declaration of Independence?
I believe that Algernon Sidney influenced the Declaration of Independence a lot because he believed in the right to revolution, and with those principles they overthrew their government, the English government, to create their own government using the Declaration of Independence.
Rousseau also, I'm sorry, go ahead, Kevin.
If I may add, Aristotle also added a lot of ideas of mixed government using monarchy, aristocracy, and polity, which are found throughout the Constitution today.
And he believes that if a monarchy becomes, say, the bad form, which is tyranny, which would mean that the king achieved too much power and therefore should be overthrown, which is what the colonists thought that the king was doing.
Thank you.
There are some today who say that the United States is a Christian nation. To what extent do you think that that's true, and how would you argue for or against that proposition based on the Declaration?
Well, I believe that in this nation, because of Amendment 1 to the Constitution, which says that we have religious freedom to choose which religion we want to practice, we have the choice not to practice that religion, but as a nation, that could be the majority that people practice, but it's not the only one in the nation.
Recently, there was a teenager who ran into someone with his car and was charged for manslaughter and was sentenced to have to attend church for 10 years. However, they didn't specify exactly what church he had to go to, even though some people were against this, saying that he couldn't have that charge, he couldn't be made to go to church because the court argued that they didn't specify. It's not against any rights.
In what sense, if any, was the Declaration of Independence a radical or revolutionary document?
Well, like Algernon and Sydney, it was the right to revolution, and they were declaring their independence, so that's why they wrote it and was overthrowing the English government.
Okay, so we are out of time for the questioning round. You guys did very well, and right now, the judges and I will give you some positive feedback, followed by some things we think you could improve on. I will start. I thought that you guys did very good presenting. You were nice and loud, so it's very easy to hear you.
I thought the timing of I was kind of amazed because you have so many people that you could get all that into the time. I thought was really impressive. I actually thought it could have been a little louder for me. I sort of lost some sort of around towards the right a little bit. Maybe just a few more times to practice those written statements, I thought, because there were a few stumbles which were totally fine, but I think that if you're in a big competition, those kind of little stumbles will make you nervous, because when you might get tangled up. So they were not a big deal, but I would think probably you and I are in the middle.
You did a good job of responding to the questions, bringing relevant points, and again, I really like to see the contemporary issues brought in, the student sentence to go to church, bring in some of the nuances that all this comes to in day-to-day life.
I think you did really well, but you all need to be confident. Earlier, you were like spot on and confident, and then you could just hear the difference, and you all know it. So have faith in yourselves, because you all know your stuff.
That's the opportunity.
And when you're reading your statement, look up a little bit more, because I noticed that a lot of you guys were sitting with your cards like this, that Ms. Brown taught us, which you take your cards out, and then it's not much difference between the cards of the judges.
Okay, so now we're going to switch to Unit 3, and the debates are going in order. The Easthampton will go first.
Hello, my name is Tristan Koopman, and I'm an alumni of this program here at Easthampton High School in Virginia.
My name is Amy Davis. I teach theater at Easthampton High School.
My name is Diane Williams. I teach geography, have taught civics, and done a We the People hearing with my students, and I also teach history electives here at Williston.
My name is Jo Winnie, and I'm a city councilor for the city of Easthampton.
Hi, we're Easthampton High School. I'm Rachel Connell, and I'm the only senior out of 36 of us. Thank you. I'm Jennifer Sage. Schaefer, and I'm a sophomore.
Hi, I'm Tom Byer, and I'm a sophomore.
Hi, I'm Sean Rose, and I'm also a sophomore.
I'm Caitlin Nardi, and I'm also a sophomore.
I'm Stephanie Kabasic, and I'm also a sophomore. And this is our teacher, Kelly Brown.
Okay, we will be asking you question number 1. John Marshall's insights in the legal case Marbury v. Madison have become a familiar part of constitutionalism around the world. One may suggest that no American contribution to constitutionalism is more pervasive or important than this one. Do you agree or disagree? Why? How would you explain the concept of judicial review? What arguments can you give for and against the power of judicial review?
Judicial review is the ability of the Supreme Court to validate or invalidate the constitutionality of government acts and laws. Although many people believe sovereignty should stay with the legislature, judicial review completes a system of checks and balances and ensures that the legislative and executive branches adhere to the Constitution, making it the most significant contribution to American constitutionalism.
The court case of Marbury v. Madison firmly established the power of judicial review in the Supreme Court system that has developed today. John Marshall argued that acts of Congress which conflict with the Constitution are not true law, and that the judiciary branch's first responsibility is to uphold the Constitution.
Many countries, such as Great Britain, Canada, and New Zealand, do not exercise the same system of judicial review, and they often lack checks and balances which exist in the United States. Without judicial oversight of congressional actions, the legislative branch would be supreme, and the fundamental rights included in the Constitution would be ineffective.
Judicial review is based on the idea of the Constitution, which guides the actions of the government as the supreme law of the land. Any actions by the government that violate the principles of the Constitution are invalid. In the United States, the most important exercise of judicial review is in the Supreme Court, which uses its power to abolish hundreds of federal, state, and local laws that have been found to conflict with the Constitution of the United States. These include cases such as Dred Scott, Fletcher v. Peck, and Brown v. the Board of Education, respectively.
The Supreme Court has also used judicial review to order federal, state, and local officials to refrain from behaving unconstitutionally and from infringing upon the constitutional liberties of Americans. For example, in the court case of Miranda v. Arizona, Miranda was not informed of his Fifth Amendment rights and was forced to sign a false confession, which was used at his trial as evidence. The Supreme Court came to the conclusion that guilty statements made in response to interrogation by a defendant in police custody would be justifiable at a trial only if the prosecution could show that the defendant was informed of and fully understood his rights. Mr. Miranda could not be found guilty since the actions taken by government officials had been unconstitutional.
Judicial review completes the system of checks and balances by adding an additional check to the executive and legislative branches. It ensures that the system of constitutionalism and higher law is upheld. Judges are in the best position to interpret the Constitution because they study it the most, serve for life, and are least influenced by politics. This ensures that the rights of minority groups are upheld by taking cases that conflict their rights to the courts, which are to be a neutral body, rather than to the legislative of both federal and state to decide, which tend to favor a majority of the population that they represent. Judicial review preserves the true purpose of our government by protecting the people from misinterpretation or abuse of the Constitution.
Despite these benefits of judicial review, it gives the Supreme Court a substantial amount of sovereignty, which some people believe should be left with the legislature, as it is closest to the people. The judges have their own interpretations and opinions, which may conflict with other branches and cause political turmoil. This is known as judicial activism. The most dangerous effect of judicial review is that the judges are far from infallible, and decisions made by the courts cannot be reversed except by a constitutional amendment. For example, in Scott v. Stanford, the court declared that all blacks, slaves, as well as free, were not and could never become citizens of the United States. This decision was later reversed by the 14th Amendment, which guarantees the civil rights and citizenship of African Americans.
Throughout American history and the government under the Constitution, the establishment and exercise of judicial review has protected the rights of Americans. It has completed the balance of the federal government by establishing the independence of the judiciary and providing a check on the legislative and executive branches, making it the most important contribution to constitutionalism. Thank you. We're ready for your questions.
what other contributions have Americans made to constitutionalism, and how do they compare in importance to the power of judicial review?
Americans have contributed to constitutionalism by enforcing the power of the judicial branch with judicial review, because before judicial review came, there really was no power of the judicial branch to oversee the executive and legislative branches.
Another important addition to constitutionalism is federalism, which is the separate checks and balances, which is another important way of constitutionalism.
Because without checks and balances, the government would be unbalanced and one branch would take over the other, and it would lead to tyranny.
And this goes back to Aristotle's idea of a mixed government with a monarchy and a democracy.
And federalism is shown in Amendment 10 of the Bill of Rights.
All right. Should the executive and legislative branches, as well as the judiciary, possess the power to declare what the Constitution means? Why or why not?
I don't think that the legislative and executive should have the power because they are devoted to one particular party, usually if there's a majority, and the judicial branches are not supposed to be swayed by politics, and they're the most educated on the Constitution and the least influenced by their political views.
I agree with my colleague. Because the executive branch, they're waiting to get reelected, so they're swayed by their party, like Jen said. And the Supreme Court justices are in there for life, so they don't have to worry about getting reelected, so they can stay to one certain thing that they believe in.
I would also like to add that if the power of judicial review was given to the executive and legislative, it would not have enough power in the judicial branch to make it as important as the other two branches.
A recent example is one of the Chief Justices in the Supreme Court used his better judgment, and he's more of a conservative judge, but he tried to prove that the health care bill is constitutional because he believed that that's best for our country right now.
Other nations, like Great Britain, allow courts to rule on the constitutionality of laws, but keep the final judgment for the legislature. Is a system such as this more or less in alignment with American values, popular sovereignty and limited government?
I do believe that having the judiciary branch having the final say does contribute to limited government by overseeing the legislative and executive and their opinions.
By giving the legislator the final say, it's giving it closer to the people, which is an American value, but I still think that the judiciary branch is in the best position to rule it constitutional or not.
Okay. How is the power of judicial review conflict with the democratic government, popular sovereignty? Some states allow for courts to issue advisory opinions. Why do you think the court refuses to advise on laws before they are enacted?
Could you rephrase the question?
Well, let me just give you the first one. So, how is the power of judicial review conflict with democratic government?
The question now is actually over.
Thank God.
I'll start out. I like that all you guys
I thought that if thought that you guys all did a really great job of focusing on your colleagues while they were answering questions. I think that's really important, and it made you guys work together really well as a team. Stephanie, you can smile a little bit more. You seem very nervous. And I understand completely why you might be, but if you smile, people won't think you're nervous. Again, also, Rachel, I appreciated the way that you affirmed what your teammates were saying when you added to that, and the rest of you could do that as well. It really helps to keep that team cohesion.
I think similarly, I liked that everybody got involved and had something to say. I would say feel free to come up with more examples, more specifics in some of these questions. What are some of those American values, and how is judicial review in concert with them, and how is it in conflict with them? I think it's okay to raise. You are good at supporting why judicial review is good and works for the United States. That was very clear. It is arguably in some ways in conflict with democracy and the ideals of democracy also. So don't be hesitant to get into some of that messier, maybe like territory. I think you're headed down a good path though. Nice job.
I think that in addition to what you're saying, sometimes even though you agree with something, pointing out some of the weaknesses actually will strengthen your argument because it makes it more realistic.
Right.
I'm very pleased on how you hit on the points of the questions, and you all seem to be able to cover and help each other validify each of the points. So that was done very well. Good job.
Good work.
Hello, my name is Tristan Goodman. I'm a junior at Easthampton High School, and I'm an alumni of the program.
My name is Amy Davis. I teach theater at Easthampton High School, and I worked with the We the People program at Easthampton last year.
My name is Diane Williams. I'm a history and global studies teacher at Williston and have done We the People in my classes.
Good evening. I'm Joy Winnie, and I'm a city councilor for the city of Easthampton.
Hello, I'm Maddie Stern, and I'm a junior at the Williston Northampton School.
Hi, I'm Olivia Foster, and I'm also a junior here.
I'm Ryan Patton, and I'm also a junior here.
Hello, I'm Scott Hendrick. I'm a junior here.
And our teacher, Mr. Gunn, is upstairs.
We'll be asking you question number 2. How did the Southern states justify their decision to secede from the United States? How did President Lincoln and other Northerners justify treating secession as an act of rebellion? And why do you think secession has historically been viewed as unacceptable?
Quote, the government of the United States has become a consolidated government, and the people of the southern states are compelled to meet the very despotism their fathers threw off in the Revolution of 1776. This quote from the Declaration of Immediate Causes which induce and justify secession of South Carolina from the federal union reveals a major justification of the southern states for secession. America was created on the belief that people had the express right to overthrow a tyrannical government. As quoted in the Declaration of Independence, it is the right of the people to alter or abolish any government deemed inadequate or dangerous.
This idea was derived from Locke's natural rights philosophy, wherein power resides with the governed. However, interpretation of this right differed greatly. The protection of state rights and power held a greater influence over Republicans who wanted to maintain the advantage of possessing a larger territory, whereas Federalists were most concerned with protecting individual freedoms through a strong national government. These ideas often came into conflict, as demonstrated in 1798 with the passage of the Virginia and Kentucky resolutions in response to the Alien and Sedition Acts, creating controversy to whether or not the states can declare federal laws unconstitutional. This idea later inspired the Confederate supporters for secession.
With the election of Lincoln in 1860, the threats of Southern secession had become such a fixture of the political scene they were regarded as empty. Few Republicans believed secession would lead to war. The South, as Secretary of State William H. Seward stated, cry out that they will tear the Union to pieces. Who's afraid? Nobody's afraid. Nobody can be bought. However, the Republican Party's lack of experience and prior to Lincoln's election, absence of a strong leader, shaped the public's view of them as feeble. This, coupled with internal party divisions, shaped Lincoln's response to the growing secession crisis. Lincoln was steadfast of his opinion of secession and firmly believed threats represented a minority of Southern states. Therefore, his chief tools for combating the growing secession movement were optimism, rejection of any negotiation on extension of slavery, such as the Crittenden Compromise, and most importantly, silence. As Lincoln famously said to dissenters, "Away off be gone. If the nation wants to back down, let it, not I."
In 1798, Thomas Jefferson wrote, as part of the Kentucky Resolution, that, quote, "Every state has a natural right, in cases not within the compact, to nullify of their own authority all assumptions of powers by others within their limits," specifically referring to the Aryan and Sedition Act. With the South beginning to identify their common political beliefs and becoming more isolated from the Union, Supreme Court Chief Justice Roger Taney ruled against the Dred Scott decision in 1857. Taney sought to resolve it peacefully, hoping to strengthen ties with the South, but by 1850 there was already, as James A. Rowley stated, repeated Northern defiance of the Constitution in deed, as in the personal liberty laws and in words. This combination of factors fueled the debate that the federal government was interfering in too many aspects of the Southerners' lives.
There was great economic inequality between the North and the South, as demonstrated during the war when the Union amassed $140 million more than the South. The South saw this as a threat to the balance between the industrial North and the agricultural South. Adding to an inflamed situation, the moral tariff of 1861, replacing the tariff of 1857, brought the debate of national power over state power to the economic front. The Southern states, especially South Carolina, felt this new tariff blatantly benefited the North. John C. Calhoun of South Carolina stated that the government has an obligation to protect the minority from the majority, and quoted from Hamilton's Federalist 51, which states, "It is of great importance in a republic to guard one part of the society against the injustice of the other part." The South viewed the tariff as a violation of the purpose of the Constitution by the general government. Their argument was that a majority interest should not always govern national policy. Therefore, the South's secession was justified in part by their want for economic equality, more so in policy than actual value.
In the 1869 Supreme Court case, Texas v. White, the court held that the Constitution did not permit states to secede from the United States, and any acts regarding secession were of no legal effect. As historian William E. Knapp wrote, "Belief in the constitutional right of secession, which a growing number of Southerners endorsed after 1846, led to an escalation of their demands on the North, heedless of the consequences. While hindsight allows us the opportunity to see the secession of 1776 as one based on the true ideals of American liberty as opposed to the secession of 1861, which is now perceived as justified by the clearly immoral issue of slavery. Even today, only 1 month after Barack Obama was re-elected as President of the United States, secessionists are circulating petitions and gathering signatures in many states. When asked his opinion on the right to secede, Associate Justice Antonin Scalia succinctly summarized the entire matter in one sentence. If there was any constitutional issue resolved by the Civil War, it is that there is no right to secede. Thank you. We are now ready to answer your questions."
What was the impact of the Dred Scott decision on the conflict over slavery and states' rights, and how did it impact the argument for secession?
Well, the Dred Scott decision, it certainly strained the northern and southern ties. The Dred Scott decision was a slave escape from his master in a slave state and escaped to free state and then went back and sued for his freedom. It causes more tension and it raises more questions than it answered.
All right. Did the 13th, 14th, and 15th Amendments close the door to any future movements for secession? Did it resolve the issue of slavery? Why or why not?
I believe though it did not resolve completely the issue of slavery, it was known as the botched emancipation. I believe it did basically close the door to any real movement of secession. As we know now, Texas has gathered a lot of petitions in a push towards secession. However, the amendments clearly put the power in a national level over the state powers. Therefore, the arguments used during the Civil War cannot be used again.
Are there any philosophical arguments that were involved in the Civil War that are still relevant today?
I believe many philosophical arguments in the Civil War are still important and relevant today, especially the idea of the power of the national government, how much power people want to have the national government to have over their lives, and how much power the national government can constitutionally exercise. The Civil War stemmed partly from the Federalists and the Republicans' differences on that one issue, which is still constantly being presented and brought up today.
I would add that these issues with the national government and how significant they are help cause some of the issues of slavery, because if there is not such a strong divide over whether people are in favor of the national government or more towards the state governments, then there would be less of an impact.
How did secession of South Carolina in 1860 differ from the secession of South Carolina in 1776?
Well, South Carolina in 1860, it had representation in Washington, D.C. at the time, and then in 1776, the colonies as a whole, they had no representation in the English Parliament.
Yes, I'd like to add, the idea that the British used was virtual representation, where you were assigned a representative. And this is not the way that it should be run, because you cannot interact face-to-face. There's thousands of miles between you and your representative. Whereas South Carolina had direct face-to-face access to its representative. They elected their representatives. Therefore, that purpose was completed.
I would add that the secession of 1776 truly showed the liberty of America as becoming a new nation compared to the 1861, where, as my peers said, was less representation.
Yeah, I would agree with what they all said and add to that point that they had the opportunity in 1860 to resolve this issue through democratic process, whereas in 1777, the only available remedy to their issue seemed to be revolution and secession.
How is it that self-determination is so acceptable, yet secession is so often derided?
I believe in part, when we look back now upon secession movements, we mostly think of this specific one in 1860, because it was so colored by the issue of slavery, which is still a sensitive subject, and even looking back on now, has impacted our nation's history. I think that because this specific secession was a culmination of a variety of reasons, not solely slavery, but it has become viewed as slavery as the main focal point of their reasons.
Okay, thank you. The question round is over. Yeah, I'd like to start with the written statement. You guys did really well. You guys seemed to know what you were saying, and you looked up and had eye contact with us a lot. I thought that was good.
I agree. You guys were very easy to understand. I would like for you to appear to be enjoying yourself, to add more. You are very serious, and you didn't start out after the beginning, whatever what's it called, the first part. Anyway, it doesn't matter. When you said your piece, I just don't know the names of all these different things. Yeah, the statement. After the statement, during the questions, and when you're answering the questions, like when you were asked the question about the Dred Scott, I really felt like you were kind of left hanging. I would have liked to have you've gotten a little bit more support from the folks on your team. And with this question, that seems like something that you should be able to speak at length about the Dred Scott decision. I also would really like more current examples of secession and how it is relevant today. You talked a little bit about Texas, but there wasn't a whole lot. I think that would be helpful in sort of making it relevant for current situations.
I want to echo what's been said. I think you did a nice job, and I think you covered the topics well. I agree with the feel free to jump in and keep backing each other up. I think that the way that the gentleman on the end of the table answered the question about started the answer to the question about the secession, the two different secessions was perfect. It was like the historical part, the little analysis, and then chimed in over here was great. Like you had, and you knew what you were talking about, and you were able to really be specific about it. More of that. You're doing a good job. You understand the topic. Now let's get real specific examples, or some of the philosophical arguments of the Civil War, you know, the conflict between national government and state government, talk about healthcare, you know, talk about some of those issues that are coming up, keep going back to those issues that are coming up that, yes, they happen all the time. These are parts of the conversation in the United States government. But yeah, keep backing each other up and bringing more to each question.
Yeah, I agree. I think that as the questions progressed with us giving them to you, you became a little bit more relaxed with each question.
Yeah.
So you started to get involved into the answering of them and backing each other up and adding to them.
Yeah.
Whereas the first couple of them, you were just like, this is the answer. Move on.
Please ask the next one.
And that's all in what you're doing this for, is the practice and getting familiar with sitting in front of strange people, answering questions, and I mean, it really is being put under the light. But you did a phenomenal job. You know your stuff, so you just got to relax a little bit.
Yeah, show that off. Say, yeah, great question. Here's what I think, you know? Play back with us. Talk with us about it. You're doing a great job.
Theatricals. But you did a great job.
Yeah.
Kudos.
Thanks,